Okay, right. Thank you very much, John. Um, so let's get right into it. So today's session is about the European patent system, and what I shall cover will be aspects of um, the system itself, some aspects of practice before the European Patent Office, and aspects of the law, which is basically governed by the European Patent Convention. Before we get into that, perhaps a quick history lesson. Um, the European Patent Organization was created by the European Patent Convention, which was signed in October 1973 and actually came into force in 1977. The European Patent Office opened its doors for business on the 2nd of November 1977. So some 57 years have now elapsed since the EPO started to operate. And I would venture to suggest that in that time, it has become a major force in patent law and practice, certainly in Europe and most likely around the world. The European Patent Convention was initially signed by just 16 countries. In the time since 1977, that number has grown, and I think we now have a total of 39 countries, which I've indicated on the screen there. Um, the detailed information on the member states of the European patent system, if you wish to go there, is obtainable at the link that I've got on the screen there, and that'll be should be an active link in the slides, which will be available afterwards. Um, the role of the European Patent Convention and the European Patent Office. Basically, the system and the EPO provide a centralized system for applying for, the examination of, and the granting of European patents. I should explain at this stage the term European patent is something of a misnomer for a couple of reasons. First of all, if you go back to the list of countries on the previous slide, you will see that really what we're talking about in terms of geographical coverage is Europe in the greater sense. All the European Union or EU countries are members of the European patent system, but as that list showed, geographically, the system covers far larger territory. So it's Greater Europe is perhaps a more accurate term. And the second reason why I suggest it's a misnomer is because whilst you get a single European patent granted by the European Patent Office, if all goes well, what you must then do is effectively select the countries or the region where you want patent protection to proceed and go through the various steps for validating your European patent. So at the end of the day, whilst a single European patent is granted, you will end up with a bunch of, in the majority of cases, a bunch of national patent rights, which exist largely independently of each other. The exception to that will be the unitary patent, which I shall touch upon in a later slide. So, just a brief comment about the harmonization of patent law. One effect of the European Patent Convention was to harmonize patent law across the member countries. Many, if not all, of the member countries have taken steps to bring their national patent laws into agreement with the provisions of the European Patent Convention. And if you want to delve into that in a bit more detail, for the UK Patents Act, the relevant section is section 130, which prescribes that a good number of the sections of the UK Patents Act are deemed to have the same effect as the corresponding provisions of the European Patent Convention. Whilst these harmonization provisions may be written into the national patent laws, in practice, some differences still remain. The patent offices and courts of the various member countries can and do take different approaches to various aspects of patent law as it applies to European patents. And one example is the novelty of so-called use claims. And I shall explain a bit more about that also in a later slide.